So I was talking with Jade and Nancy, and it's been since 2019 since I was up giving this this type of presentation. But my name is Judith. I live and work in Manchester, New Hampshire. I've been practicing as a trust and estate attorney for the last 20 years when I moved up here, and I've been specializing in disability planning, special needs planning. Been trying to give back to the community. We helped to write the supported decision-making statute with the Disability Rights Center, and so thank you all for coming and sharing time with us today to talk about special needs trusts and ABLE accounts.
And I'm Alisha Cahall. I share Nancy's sentiments when it comes to Judith. Judith is my mentor, and she's a wealth of knowledge for me and will be for all of you today. And I am not new to New Hampshire anymore. I've been here for about 2 years. Before I did special needs, reviewing IEPs for the New York Department of Education in their special education unit. And then I moved up here to New Hampshire and started doing estate planning, special needs planning with Judith, doing some guardianship work, estates and trust work, probate and trust administration with Judith. So with that being said, I just want to jump in. So this is my first in-person presentation, and I must admit I am a little bit nervous, so please bear with me. All right, so we're so grateful for the invitation to be here this afternoon, and we've been asked to speak with you all about a primary planning tool, special needs trusts, that are used to assist persons with disabilities to preserve benefits that are based on financial need, like supplemental security income, and the acronym that I'm going to use and Judith is going to use today is SSI, and certain Medicaid programs with countable resource limits. We'll also touch briefly on another tool called the Achieving a Better Life Experience Account, or ABLE account. The goal is to focus on what these tools are, when they are needed, and why clients with disabilities use SNTs and sometimes ABLE accounts for immediate and future needs. We have prepared a few slides, and if there's time, we may do a very high-level view of guardianships and alternatives, although we are scheduled to do a presentation here on July 23rd to do a deeper dive, and we hope to see you all again on the 23rd. So, thank you.
You're welcome.
Helping to plan for the long-term well-being of someone with disabilities is a delicate dance. Whether that client is the actual person with disabilities or a loved one focusing on the life care of another, to ensure the individual continues to receive the care and support they need while also preserving their eligibility for essential public benefits. A whole segment of our population relies on public benefits, some for a short period of time, others for life. There may be many different public benefits programs, which some in the audience may already know. Some government benefits offer monthly income to an individual, while others provide essential medical services. Some offer 24/7 care for developmentally disabled children or adults, and others offer respite, daycare, residential housing or supported work programs, and food assistance. Some programs have income and resource limits for eligibility, while some only look at a person's taxable income. Benefits programs are either run solely by the federal government or jointly by both the federal government with the states. So for example, Medicaid is a jointly run state and federal program, and New Hampshire Medicaid rules will be different from Massachusetts Medicaid rules. Slide. Because of the complexity in the various types of government benefits available, it is critical to understand some of the common pitfalls that might arise. Many essential needs-based government benefits, that is government benefits with very strict income and or resource limits, can be placed at risk if someone receives assets like an inheritance or a personal injury settlement outright. For example, if a grandparent gives $18,000 a year to each grandchild, even to one who is disabled and on benefits, the gift could disrupt essential services because a grandchild, if on a benefits program with strict financial eligibility criteria, often can't own assets above certain limits. The recipient also may be unable to give the money away and remain eligible for assistance. So the recipient, the disabled grandchild in the example, could be at risk of losing their benefit. Although there are various options available to plan for someone with disabilities, today we will be touching on special needs trusts, which the acronym we're going to be using today is S&Ts, and ABLE accounts. S&Ts and ABLE accounts are exceptionally useful tools and are key to planning when the goal is preserving means-tested public benefits. That is government benefits programs that considers the individual's income and resources. Both S&Ts and ABLE accounts have mechanisms for sheltering and managing resources to enhance the life options of the individual with disabilities while still preserving eligibility for benefits that might offer the person essential supports, whether in the form of cash or medical assistance. S&Ts and ABLE accounts serve the same objective of holding assets for future use. However, they accomplish the goal in slightly different manners. Before we dig deeper into when and why S&Ts and ABLEs are used, and some of the key features of these tools, let's first discuss how the public benefit systems work and certain government benefits options that may be available to someone with special needs. Because while there are many benefits available, S&Ts and ABLE accounts are not needed to preserve all types of government assistance. Next slide.
I know, I jumped ahead.
So how does the government benefit system work? At their most fundamental level, there are cash assistance programs from the federal government that require individuals to either meet financial eligibility criteria, that is, meet certain income and or resource limits, or have the requisite work history. For some of the most critical safety net programs, you must be disabled to receive government assistance. Judith will give a brief overview on some of the core benefits, which sets the stage to put S&Ts and ABLE accounts in context for planning.
Thanks for the foundation. We wanted to make sure that we were all had the same kind of basic understanding of the public benefits at issue, because as Alisha just mentioned, special needs trusts and ABLE accounts are only necessary to preserve certain types of needs-based benefits. So we wanted everyone on the same page, talking about some of the core government programs. So we're going to be talking about Social Security, and it comes in a couple of different flavors. There's Social Security retirement, which we're really not going to be digging into. There's Social Security disability insurance, which we'll call SSDI, Supplemental Security Income, SSI, as Alisha mentioned, and Medicare and Medicaid. And we put together some, in addition to the slides, we have some charts that we've just prepared with some helpful information on comparisons. I'm going to dig down a little bit deeper in our discussion today, but hopefully the charts are helpful at a glance on comparing the cash assistance programs and the medical assistance programs. And then at the tail end, we have one to sort of bring S&Ts and ABLE accounts comparisons and wrap it all up with a nice bow, hopefully. You want to run the show? There we go. This is good. So when it comes to government cash assistance programs, there are 3 core programs, as I mentioned, that offer monthly checks, but only one of them is going to be necessary for using a special needs trust or an ABLE account for preserving assets and not have the assets countable toward the individual's low threshold for resource limits for that particular program. So Social Security retirement is tied solely to work history. Again, I hope to retire at 65, but we're not going to drill down on that one. Social Security disability insurance, SSDI, that is a cash assistance program that's tied to work history as well as the existence of a proven disability. SSI, supplemental security income, I remember writing an article about what a difference a D makes, because between those programs, they're incredibly different, but they sound a lot alike. SSI is tied to a person's proven disability, but the individual has to be financially eligible for supplemental security income. So they have to have a low asset threshold in order to be eligible, and a low income threshold as well. So I want to drill down a little bit deeper on Social Security disability insurance. Sometimes clients and families come into our office and they say, I have a family member that I want to plan for, and they're receiving a disability check. So the first thing we're going to ask for is, can we see the award letter so that we know what type of cash assistance they're receiving from the federal government? SSDI and SSI are a purely federal system program. As Alisha mentioned, Medicaid is a joint state and federal program. So we're looking at both federal rules and state rules when it comes to Medicaid assistance. To be eligible for SSDI, someone has to be tapping into a sufficient work history. When folks pay into the system, or when a parent pays into the system, if there's a child with disabilities, if they've insured themselves, if they've worked for a sufficient number of quarters. If they become disabled, the definition of disabled under the Social Security rules means that the person can't engage in what Social Security says is a substantial gainful activity. They call it SGA. I wish there wasn't so many acronyms in the public benefits world. But to be disabled and not to earn a substantial gainful wage, disability has to be based on a physical or a cognitive impairment that is expected to last at least 12 months or result in the individual's death. Someone seeking SSDI, as I mentioned, has to be tapping into a requisite work history. So at least 40 quarters, I think, in the last 10 years. I'll be making sure that that number is correct when we look at the tape. If so, then that person has insured themselves if they become disabled under that definition I just described. Notably, I want to mention that a child can tap into a parent's work history if a parent has paid into the system for a sufficient number of quarters, if that child's disability has arisen before age 22, and if that parent is retired, disabled themselves, or passes away. And that's called a disabled adult child benefit. They've changed the name to childhood disability benefits, but it's a way for a child to tap into a parent's work history rather than going the route of the next benefit program, which I'm about to talk about, which is supplemental security income, which is not tied to work history. It's tied to disability and financial need. Thanks for moving me ahead. So SSI works really differently than SSDI, and typically it's offering a far more modest monthly check to the individual because it's not an insurance-style cash assistance, it's based on need. So as I mentioned, SSI is for folks who don't have that sufficient work history to tap into. And the individual similarly has to be blind or disabled under the Social Security rules because it's based on disability and financial need. But because that benefit is not tied to work history, there are these strict financial rules that Alisha was mentioning early on. And the government is looking at how much the individual has in assets in their own name, and what is that individual earning on a monthly basis or receiving on a monthly basis in wages like earned income or unearned income, assistance from another source, whether that source is a trust or an individual. And so SSI cash assistance basically requires the individual who's applying to remain poor, not have assets that are available and within their own control. For our special needs trust enabled discussions today, I think one of the key takeaways that we wanted to mention is without the special planning tools, someone who's receiving supplemental security income based on financial need and disability, not work history, can only have $2,000 in countable assets. That's a very low threshold. Countable resources include things like cash, bonds, securities, anything that can be easily liquidated and pay for the things that SSI is designed to pay for. SSI is designed to pay for someone's food and shelter, their basic needs. And right now, and it's hard to get my head around it, but the maximum monthly SSI check is $943. And that's going to be reduced by earned or unearned income.
Does that count like if they have a car or like an asset?
Nope, so there are some non-countable resources. Okay. So they don't force you to sell the car. They don't come into a home to tally up the tangible property. I think when folks are applying, I tell clients, if you have gold bullion sitting in a safe, that's not tangible property, that's actually money. They're not looking at, does someone have a collection or a coin collection, things like that. So it's a great question. So I want to move on from the cash assistance, and we're going to talk a little bit about how these cash assistance programs fit with the special needs trust enable accounts. We just wanted to make sure that we all had the same foundation on the benefits that need those tools. Alisha had mentioned that core public benefits programs offer medical assistance as well. The federal programs offer that cash assistance on a monthly basis. In addition to needing help with those basic monthly expenses, someone with atypical needs might need help covering medical care for prescriptions, might need case management if there's a mental health issue. They could need 24/7 care in a nursing home. They could need a number of hours a day or supported work environment assistance for someone who's on like Medicaid for employed adults with disabilities. So there's a lot of services that are available. There are two main types of medical assistance programs that we're going to talk about, and there's a comparison chart of Medicaid and Medicare, very high level view. But Medicare is a federal program that's available to anyone who's paid into the system, like Social Security disability insurance, but it's available to anyone who's over the age of 65, or if that wage earner who's paid into the system becomes disabled or blind before the age of 65. Medicare is going to be tied to their Social Security disability insurance check. That's true also of a child who is tapping into a parent's work history, riding that parent's coattails with that disabled adult child benefits. That child is also going to be able to tap into Medicare. There's a wait, however, for most Medicare programs. I mean, there are some exceptions for dialysis, I think it is.
Right, so Medicare is available for someone with end-stage renal disease as well. If you're under 65 and have end-stage renal disease, you can tap into Medicare.
Yeah, and but there's a 2-year wait, however, after Social Security disability insurance kicks in. So it's just, I had to deliver that news to someone last week, and they were asking me why that is. And I think it's just a fiscal note somewhere in the legislation to, it's been around for decades, that 2-year wait. So if, because Medicare, that medical insurance, is tied to work history, and because Social Security disability insurance is tied to work history, those are insurance programs. If you pay into the system, you've insured yourself. If you become disabled or you meet that age criteria, you're entitled to those benefits. And so the government doesn't care if you have $3 million sitting in the bank. If you've paid into the system and you become disabled, you're going to be entitled to SSDI. If you're over 65 or disabled before that age and you paid into the system and you've waited 2 years, you could have $2 million sitting in the bank. It's tied to work history. And so Medicare just simply doesn't care how much folks have in assets. They do, however, care whether or not you can earn a substantial gainful wage if you're under 65, because that's sort of the definition of disability. You have a cognitive or physical impairment. That's a permanent disability, and it prevents you from earning that gainful wage. So unlike Medicaid, unlike Medicare, Medicaid, as Alisha said, is a joint state and federal program. And many Medicaid programs require determination of disability in order to become eligible. There's a lot of states around the country where if someone applies for SSI and becomes eligible, they are automatically eligible for Medicaid. New Hampshire, we're the Wild West. we're what's called a 209B state, which just means that we have a separate Medicaid determination. It's not tied immediately to the Social Security determination. So it feels like families are jumping through these hoops a second time in order to get the state Medicaid assistance. The programs, as Alisha had mentioned, offer a lot of critical support. So risking the loss of those is problematic. The federal SSI cash assistance and the Medicaid programs are based on financial need because they're not tied to work history, like SSDI and Medicare. And some of the Medicaid programs have both income and resource limits when determining the financial eligibility. Others are just looking at the individual's modified adjusted gross income, yet another acronym, MAGI, M-A-G-I. Usually, as I said, Medicaid services are so essential to the individual that the risk of loss is incredibly traumatic, and the goal is to try to do advanced planning when there's time for advanced planning, but we are going to be talking about some safety valves that are built into the federal law when you can't do advanced planning. Different types of special needs trusts that we're going to drill down on in a few minutes. So I did mention MAGI. When we're talking about special needs trusts and SSI and Medicaid, we're talking about more traditional Medicaid programs when we're trying to illustrate special needs trusts and able accounts in a few minutes. But I did want to mention the MAGI program because we're doing a little primer on the benefits. But as I said, MAGI looks at a person's modified adjusted taxable income. And so someone who's between the ages of 19 and 24, if they're not otherwise on another type of Medicaid program or another, or Medicare, with one exception that I'm aware of from a client, end-stage renal disease, and they're looking at whether or not the individual, it's not based on disability, they're looking at whether or not the individual's income is a certain percentage above the federal poverty level. And like many of the rules relating to public benefits, it sometimes feel like we're on shifting sand because the rules are constantly changing. Right now, it's like 133% above federal poverty level. MAGI Medicaid is not tied to disability. As I mentioned, it doesn't have a resource or asset limit, so it doesn't care how much is sitting in the bank. They're looking at taxable income. They care how much is sitting in the bank if that taxable income is throwing off a lot, that asset is throwing off a lot of interest and a lot of taxable income, then they care. But it's important to keep in mind that if someone's solely on MAGI Medicaid and not a traditional Medicaid program, a special needs trust is probably not needed because they're not looking at the assets sitting in the bank. They're looking at the individual's taxable income.
I'm not aware of MAGI being a waiver of Medicaid. No.
No, and it's through Granite Advantage, so it's part of that expanded Medicaid program. So the state could close ranks and limit it.
If a person needed area agency services,
Yeah, no.
Well, they want to go down because they wouldn't be able to.
They could do it.
I'd need to take a look at the
But they couldn't get
all the breadth of it. Yeah, the breadth of the services. And I am aware that there is, anecdotally, sometimes we pick up the phone and we call sort of, someone at the Department of Health and Human Services and get an answer, and it works in that particular case, but I can't say that it's broad. We know that MAGI was covering some choices for independence living for adults who need nursing home level of care on the MAGI program, but I can't tie that to a rule right now, and I can't ground it, so I don't want to say yes, it's available. Yeah.
In terms of the 2-year wait you mentioned, so is that in terms of the Medicare?
Medicare only, yeah.
Right.
Medicare tied to SSDI.
So usually folks that are on SSI after 2 years will magically get a Medicare card.
Yeah.
Is that the 2 years?
It's probably the 2-year wait, but they may be shifting over from SSI to SSDI at that time. So I have some folks who are on SSI at 18, and they've been on it, and they're on Medicaid for a period of time, and they shift over to the disabled adult child benefits because of a change in a parent's circumstances. Yeah. So we
But
can.
if you're just on SSI,
Yeah.
and you don't have any earned income,
You're not shifting over to
Then you're not
Medicare.
gonna get Medicare,
Mhm.
you're just gonna stick with Medicaid.
So just remembering that Social Security disability, I'm sorry, Nancy. Just remembering that Social Security disability insurance and Medicare are the kind of the lockstep. And Social Security retirement and Medicare are the lockstep because those are tied to work history. And then SSI, supplemental security income, that's based on financial need. Medicaid is based on financial need. And so those two are traveling together. So for SSI, thank you. So for SSI, the individual can only have, as I mentioned, $2,000 in countable resources, cash, stocks. I can't tell you how many times someone is approaching age 18 and a grandparent bought bonds in that child's name because they thought they were, going to be on a same trajectory as other grandchildren. So it's anything that can really be easily liquidated. But frankly, when someone comes in and we're looking at the assets of the individual and we're trying to help them get onto benefits, we're looking at the Adult Assistance Manual or the Medicaid Assistance Manual because things change at the state level on how they define countable resources. For non-MAGI or traditional Medicaid programs, the one that have asset limits and income limits, those program limits could run from $1,500 cash in the bank, and I'll just say cash, that's any countable resource, to $7,500. They changed the rule recently for Choices for Independence. I don't know why they don't just say it's a $7,500 resource limit. They say it's $2,500 plus a $5,000 disregard. I'm like, well, just say it's $7,500. It would just make it easier for us all. And so others, individuals with disabilities, if they're able to work, they could be on a program like MEAD, Medicaid for Employed Adults with Disabilities, which allows them to have a lot more in the bank and may not need a special needs trust, but might need an ABLE account where they can tuck some extra assets into. Not all resources count, so thank you for that softball. You got to it early. And so it's just really important to take a look at what counts and what doesn't count, as I mentioned. But the important takeaway for today is that assets that are sitting in a properly drafted special needs trust, and we're going to talk about the different types, are not countable toward the resource limit of the individual beneficiary who can benefit from the assets. And they're also not counted when they're sitting in an ABLE account, up to certain limits, which we're going to talk about too. So I do want to mention that SSI and Medicaid also don't just look at assets and asset limits. They're also looking at income limits of the individual. And I mentioned that the government programs are asking at application and at recertification dates, what is the individual who we're giving benefits to get in earned and unearned income on a monthly basis. And the agencies are also looking at what's known as in-kind support and maintenance. They call it ISM, I-S-M. And that's when another source is providing shelter and food assistance to the individual. And if that's the case, that's unearned income. And it's going to be counted against them and reduce that person's SSI monthly check. Not dollar for dollar, a third, but it is going to have an impact. And we're going to talk about the earned and unearned income rules when we talk about distributions from special needs trusts after we unpack what those are. So the rules regarding income eligibility are incredibly complex. The Program Operations Manual, the POMS for the Social Security Administration is that organization's Bible. So if I printed it off, it's going to be taller than I am, page on page. And you really have to sort of navigate it to figure out what might be income or not, earned income or unearned income, ISM or not. So I'm going to kick it over to Alisha to talk about special needs trust now.
Okay. So we've mentioned a few times now that SNTs and ABLE accounts are only needed to preserve certain government benefits. SNTs are needed only for SSI and the many traditional Medicaid programs. These are the programs, again, as we keep trying to hit the nail on, these are the programs based on disability and financial need with resource tests. And it matters what someone has in the bank or investment accounts or an inheritance trust that might mandate support. On the other hand, programs like SSDI, Social Security Retirement, and Medicare are tied to work history and simply don't need an S&T to preserve them. Likewise, as Judith mentioned, Magi Medicaid looks only at modified adjusted gross income and should also not need an S&T or ABLE account to preserve assistance. Next slide. So let's now get into what is an S&T and how it helps to preserve assets for future use and essential government benefits at the same time. An S&T is a trust arrangement, meaning someone is appointed as trustee, and that person acts as a fiduciary to manage assets long-term for a beneficiary, the person with disabilities, who benefits from the trust funds that are set aside in that S&T. The beneficiary, again, the person with disabilities, doesn't own, control, or manage the assets in the S&T. They simply just can't have any power over the assets that are put into the special needs trust. But the trustee can use the funds in specific ways to pay for things that government benefits like SSI and traditional Medicaid don't pay for. So it's used to supplement SSI and Medicaid. A well-drafted S&T ensures that the trust assets, or just drilling down on this, are not considered owned by or counted as available to the trust beneficiary. Also, some types of income streams that are irrevocably assigned to a properly drafted S&T. For example, court-ordered child support to that S&T won't be countable towards the program's income limit. And if trust distributions are made carefully, the money coming out of the S&T won't be counted as additional income to the beneficiary. So essentially, what we're saying is a well-drafted, and carefully administered trust ensures the beneficiary doesn't lose benefits that have asset limits. What does an S&T look like? Well, first,
can I just ask you a quick question? Over my years here, I've noticed a lot of people come into us and say, oh, my lawyer drew up a special needs trust. Can you share with the group why it's important to find out the credentials of the attorney doing the trust? Because not all attorneys, they say they can write one, but if they're not, you can kind of expand on that.
Yeah. So, I've seen a lot of special needs trusts that have some provisions that are problematic. So we're going to talk a little bit about third-party special needs trusts, which are trusts created by family members for someone they love. They want to set aside an inheritance. And self-settled special needs trusts in a minute. I want to say one of the examples is I'll see provisions that are from a self-settled special needs trust, like a requirement to repay Medicaid when the beneficiary dies, in an inheritance-style third-party trust, and it just shouldn't be there. I'll see provisions that, and it may be that the client wanted them, that are very restrictive in terms of what a trustee can make distributions for. They limit it to a certain class of what they define as special needs distributions. But it's really hard to figure out the needs of an individual on the date that you sign it, or the landscape of the benefits at the time it's going to be used. And so, it's really important to have folks who are building in some safety valves to give the trustee a lot of discretion, maybe some checks and balances on the trustee that I don't see in there. And I've had unfortunately stepped in for a case where a trustee stole money from the beneficiary from a special needs trust, and I got appointed to sort of resolve that issue. So you just want to make sure that there's enough in the trust to really ensure it operates the way it's designed to. And also understanding if the person that you're meeting with has a thorough understanding of the benefits that are at play. Because if someone, as we said, is on SSDI and Medicare, and it's unlikely that they're going to need additional assistance that the Medicaid program would offer, then we want to be thinking about other considerations. Is there other planning that can be done for this individual? And so we're going to be talking about some of those issues in a few minutes. Yeah.
okay.
Sorry.
All right, so what does the S&T look like? We said first it must be a written trust agreement. And once assets such as money, stock, or real estate, or an inheritance or lump sum settlement, or the wealth of a person who becomes disabled later in life goes into the trust, the S&T generally becomes irrevocable, meaning the trust terms can't change. And for self-settled special needs trusts, which we'll discuss in a moment, those must be irrevocable from the outset. The trustee or person in control has absolute discretion whether to distribute assets or not. So S&Ts are discretionary, but they are not mandatory support trusts. The goal is to supplement public benefits, not provide full support to the beneficiary. S&Ts should also include spendthrift provisions to prevent the voluntary and involuntary assignment of trust assets to others by the beneficiary. S&Ts are protected from creditors, and a beneficiary or even a guardian can't demand a distribution be made from the S&T. The trustee is the one that has that discretion to make a distribution. Generally, the individual with disabilities is the sole beneficiary of the S&T during life and must be the sole beneficiary for certain types of federally sanctioned self-settled S&Ts, which again we're gonna get to. So, as mentioned, to understand whether an S&T is needed in the first instance, it's essential to know what type of benefits the person is receiving. Someone coming into money who is on SSDI, which again is based on work history, won't need an S&T to keep the SSDI going, but would need an S&T if they're receiving or if they plan to become eligible for SSI or to get certain Medicaid eligibility. It's critical to determine whose assets are going into the S&T. So did the assets belong to that person, that individual with disabilities, or to someone else, a third party? Other requirements to consider for an S&T include the age of the person with disabilities and whether there are any special requirements in the person's home state. Again, Medicaid is a joint state federal run program, so we're looking at things like that.
So bear with me a second. I want to just respond because it just brought up when you talked about the age of a person with disabilities. I had an attorney up in the North Country call me because they had a client who was over the age of 65, and they settled a case and came into money, and the attorney that they were working with wasn't aware that there was an age restriction for dropping that money into a special needs trust. So we're unraveling that. So I just think, there's a lot of, it's not that the folks can't learn it, because I learned it and Alisha is learning it, and it's not rocket science, it's woven together in a lot of different ways, and there's all of these pitfalls built into it. So, sorry.
And I have to say that Judith's mind works where she can see an issue and then she can put all the issues below it. I think my mind is more like a net, and I'm trying to capture everything and then put it into something more cohesive. Okay.
You see things I don't see.
All right, so we're at 17. All right, got it. All right. 18. So there are two general types of special needs trusts which serve the same purpose. That self-settled special needs trust, which is funded with the assets of the beneficiary. For instance, if an individual who is already on traditional Medicaid or SSI inherits money or settles a personal injury action, or if someone who never needed Medicaid until now has too much money in the bank, they would create a self-settled special needs trust. So it's a trust for themselves to house their own money. A third-party special needs trust, on the other hand, is funded with the assets that belong to someone else, a parent, a loved one, a friend, not the person with disabilities. And often the third-party S&Ts are created by a family member or friend as a part of their overall estate planning for that loved one. Funds going into the S&T never were owned by the trust beneficiary in a third-party special needs trust. Whether created to hold money set aside for a loved one, third-party special needs trusts, or to hold money that previously belonged to the benefits recipient, the self-settled special needs trust, if the S&T is created and administered properly, the S&T's assets won't count toward program resource limits because funds won't be considered owned by or available to the trust beneficiary. And as long as distributions from the S&T are made in a proper manner and for permissible purposes, the funds coming out should also not be considered the individual's countable income. We will discuss what types of trust distributions are considered the individual's countable income in a moment.
I know we keep saying in a moment, in a
I
moment.
know.
We're just layering and building. So I'm going to be talking a little bit about the different types of special needs trusts. And Alisha teed it up by saying there's two categories, self-settled and third party. Yes.
I'm sorry, quick question. Can there be more than one S&T for the benefit of a person?
There can.
Okay, for instance, let's say that a person has, say, like a 1/10 interest in a testamentary trust, and then a separate relative has a windfall that creates a separate trust.
Yep.
Can those two S&Ts exist to the benefit of that one person
Yes.
as separate S&Ts, and then also an able account exists for that benefit of that person?
Yes, there can be more than one special needs trust for an individual. We're going to talk a little in
Okay.
contrast for able accounts, because there can only be one able account for
Because
the
that
individual.
100,000 one still exists, or is it 100,000 per S&T?
There is no $100,000 limit for S&Ts. So we're going to talk about the limits. S&Ts, sky's the limit for what it can own, how much it can own. Able accounts do have some limitations, and we're going to talk about that in a
Thank
few
you.
minutes.
If
Yeah.
has already got a special needs trust,
Yes.
but it was written where they do have to pay back Medicaid, can they get rid of that one? How does that work?
Okay, so let's get I'm going to park that. No, I'm going to park that one in the garage because it's a sophisticated question, so I'm going to just park that one. S&T, self-settled, how to get rid of, and if you can. Okay. So if you don't mind, I'm going to table that one. I want to get sort of the foundation of what these different types of special needs trusts are, so that we are all on the same page. So I'm going to start with self-settled special needs trusts. There are two types of federally sanctioned self-settled special needs trusts. These are safety valves that are built into the federal Medicaid and Social Security supplemental security income rules. So Alisha had mentioned that if a person is on SSI, and SSI has a $2,000 countable asset limit, unless you have a special needs trust or an able account there, and they come into assets, or if that person is on Medicaid, and let's say that Medicaid program has a $1,500 resource limit, they can't just turn around and give away those assets to someone else. If they come into a PI award, they can't just give away those assets. They can spend them down. DHHS wouldn't have a problem if they spent it on non-countable resources. But depending upon the size of the settlement or the size of the inheritance, it might not be practical, and they may want to be setting aside those assets for their own future needs, but still preserving the benefits that are essential for their day-to-day living. So federal law offers some safe harbors to allow individuals with disabilities to transfer their assets into an irrevocable trust where they're not the owner anymore, and they're not the person managing and making decisions on distributions, but they can benefit from the assets in some way without triggering a penalty from their benefits that they're on. These two types of self-settled special needs trusts are either called payback trusts or pooled trusts. And I'm going to talk about the two different types. And they're usually referred to by the section of the federal law that created them. They're D4A trusts and D4C trusts, but we're going to talk about them as two different types of self-settled special needs trust. So the first type I wanted to describe is the D4A, or the payback self-settled special needs trust. So the person with disabilities who's putting their assets into that irrevocable trust, locking them away, giving a trustee control over making decisions about distributions, rendering those assets non-countable for purposes of those low threshold limits for Medicaid and SSI, that individual has to be under the age of 65 to create and fund that D4A self-settled special needs trust. It can be created by a parent, a grandparent, a guardian, a court, and as of a couple of years ago, probably I say a couple of years ago, it's like 2016 now, it's by the individual. They can also create that special needs trust. Most importantly, That D4A trust has to be for the sole benefit of the individual with disabilities, so it can't be a trust that has that person who puts their money in there and their children benefiting from it. It can only be for the individual with disabilities who's putting their assets in there. And even more importantly, because this is a safe harbor provision, the D4A self-settled special needs trust requires that on the death of that beneficiary, any assets remaining in that trust are required to repay Medicaid for whatever that individual has received from Medicaid throughout their lifetime. Okay, so it's a Medicaid payback trust, yeah?
Okay, so I want to just clarify something. So the trust can be created by the individual with disabilities, a parent, grandparent, guardian, or the court, but it can't be funded with that parent's or third party's money. It has to be funded with the individual who's receiving like that settlement from a personal injury award. It's their money. It can be created by somebody else, but it has to be funded with that person's money.
So I'm going to add one nuance to that. It actually, it shouldn't be funded with the third party's funding, because it means that it shouldn't, yeah.
Shouldn't.
It should not, a family member shouldn't drop money into a self-settled special needs trust. That should only receive money of the individual because it has a Medicaid payback. A family member should create a third-party special needs trust, which I'm going to talk about in a minute. That has no Medicaid payback. But I have some folks who've said, listen, I'm setting aside a $10,000 inheritance. We're going to use that. Can I just drop it into that self-settled trust? They can, but they're exposing it to a Medicaid payback, and they really shouldn't. Go ahead.
When you talk about the Medicaid payback over the lifetime, is that counting just the cash benefit the individual received, or the price of the insurance? That
All Medicaid assistance provided to the individual during their lifetime.
Okay, thank you.
And yes, it does. There are certain things that you can leave outside of the trust that only have Medicaid recovery after age 55, but inside the special needs trust, you're exposing it to Medicaid assistance from the dawn of time. Yeah, I have two.
Why the heck would somebody do that?
Because they have no other way to set aside their resources and stay on the assistance they need. So they have to put it
So it's
somewhere.
like a safe harbor,
It is a
will,
pure safe harbor.
you don't necessarily want to have because you're exposed.
Exactly, you can't give it away, and you might not be able to spend it down, but you want to set it aside in a vehicle that can be used for your benefit. But the quid pro quo, the federal government says you can't give your money away, turn around the next day and get certain types of Medicaid program or Social Security, but you can put it in an irrevocable trust, not own it, turn around, as long as you repay Medicaid at the end of the day. Okay, so we're going to do some questions at the tail end, but go ahead. We'll do these two, and then we're going to hold just a little bit so we could get through things.
So D4A has a Medicaid repay, but D4C does not.
D4C does. So we're
Oh,
going
it
to talk
does.
about D4C.
Sorry.
Yep. So, as I said, they just refer to them by the. Oh, I'm sorry. Go ahead. You had a question.
For the Medicaid payback, they just take whatever's left in the account
Yep,
upon
they
the death. They're not gonna, are they gonna like build?
They can't go outside the bucket. So if there was $1.50 left and a $100,000 Medicaid lien, they get the $1.50. Yep. Yeah. So there's a D4A self-settled special needs trust. Has to be created and funded by an individual under the age of 65, created by a parent, a grandparent, a guardian, or a court, and the individual themselves. It's for the sole benefit of that person because they have to put the money somewhere, and they want the benefits and they want to use the money too, and it has to repay Medicaid from the date they started getting assistance forward. Okay, so that's the D4A trust. Pure safe harbor. You don't use it unless you need it. The D4C trust is also self-settled. Did you click ahead for me? You did. Yep. So, and it's also called a pooled special needs trust. And it's the reason it's called a pooled special needs trust is how this trust operates. So the list of people who can create that pooled D4C self-settled trust is identical: parent, grandparent, guardian, court, or the individual. And while the federal law doesn't actually say you have to fund it before age 65, or else they're going to impose a penalty period and a denial of benefits, New Hampshire is part of Region 1 for the Center for Medicare and Medicaid Services, CMS, and CMS issued a memo to all of the folks in the region that interpreted the statute to say, even though it doesn't say under 65, you have to be under 65 in order to fund it. Now, some states have challenged that, but New Hampshire is lockstep. So self-settled, if you're over age 65, we're looking for some other option because we're not able to put the funds of the individual in a pooled trust or in that D4A trust. But there are some differences for how those trusts operate. So the D4C pooled program, and there are several or nonprofits who operate the program in New Hampshire or serve New Hampshire beneficiaries, but the D4C program is managed by a nonprofit organization. So it's not a family member who's managing the funds. It's not a family member who's deciding on distributions. It's managed by a nonprofit. And the program itself is already in place. So folks aren't, if they need a D4C trust, they're not going to a lawyer and drafting that self-settled special needs trust from scratch and naming the individuals they want as the trustees. The program is already in place, and they're joining that program and creating an account, and it's managed by the pooled program. And the reason it's called a pooled trust is that all of the assets, every individual's money, sorry for the hand puppets, but every individual's money is going into a separate account used for the sole benefit of that beneficiary. But when it comes to investing, it's pooled for investment purposes, kind of like a mutual fund gets pooled, but every person who owns that little percentage of the mutual fund, it's their money. So that's why they call it a pooled trust. There is one nuance on the Medicaid payback for the pooled trust program, because the federal government wants the nonprofits to be able to continue their mission of serving individuals with disabilities. If Medicaid would get 100% of what's left in that remaining trust at the death of the beneficiary, a percentage can go to the nonprofit first and the rest can go to Medicaid to help it continue its mission. But only if 100% would have gone to the Medicaid agency does that nonprofit get to play in that sandbox. So when to use a D4A trust or a D4C trust? Again, self-settled trusts, self-settled money, trying to preserve that individual's own benefits. For a D4A trust, where you're going in and meeting with a lawyer and working with a lawyer to set it up from scratch, someone might want to have their own trustee. They want to select a family member. They don't want a nonprofit. They want that personal touch. I've had some folks who owned a business and then suffered an accident. They needed to get on Medicaid, and they didn't want to sell the business. That business went into the special needs trust, and it's a special type of asset. And so they needed to structure the trust and get the trustee in place in a way that makes sense for operating that. And if they have time, if they're not getting on benefits immediately, and they have time and they want to tailor things. I've had some folks who want to do that D4A standalone trust with me because they want to put 3 family members as a committee to meet with the trustee and figure out distributions and set a plan for the beneficiary. That's not a model under the pooled programs. Those programs have their own terms, and you're joining it and buying into it. A person might choose a D4C if they don't have a lot of time to spend down, and if it's a modest amount of money. So I have some folks who might have, I say modest amount, but $20,000 rather than hundreds of thousands, and they don't want to go out and replace a car. They're not sure what they want to do, and they don't want to spend down in the month they receive the assets, because those assets are going to be countable in the month after they receive it if it's still in their name. So they have to put it somewhere. And so the pooled program's already in place. They can join that program, drop the money in, take a breath, and figure out and work with the trustee on maybe some distributions that make sense for them. Bear with me one second. And so D4Cs, some folks really like having a skilled manager who knows the Department of Health and Human Services, knows how to report and help with recertifications, is going to stay up on the changes in the public benefits rules, so that an individual who's serving as trustee, they can hire someone to help advise them, but those nonprofits they're following changes in the program manuals. They're watching changes in the Medicaid rules, so they know how to administer the special needs trust. There is a fee for that, and a family member might not charge a fee. So there's all of these things that we talk to family members and individuals who are funding assets into a self-settled special needs trust.
So you have a month after you receive assets to create a trust?
If you come into assets, you don't have a month to create it, but it's income in the month received and it's a countable resource in the month after. So you have, it's not, you don't have 30 days. I hear people say, oh, I've got 30 days to spend down. I've had people come in and they have they're holding a check and it's the 22nd of June. And I'm like, you've got, 8 days?
Yeah.
I'm thinking, is it 31 days? No, that's July.
Yeah.
So yeah, they've got 8 days. So it's a countable resource in the month after the month received. So it's really important. So sometimes that D4C trust is really a key player, a key tool. Yeah. So I'm going to talk a little bit about third-party special needs trusts. So again, there's self-settled and third-party. Self-settled has two types: safe harbor, driven by federal law and requirements. Third-party trusts are creatures, they're not creatures of federal law. They're creatures of common law. They're trusts. And what they're, unlike self-settled special needs trusts, they're driven by the New Hampshire Trust Code on what you can and can't do, what you can and can't write into them. Alisha had mentioned, special needs trusts are fully discretionary. The trustee of a third-party special needs trust, just like the trustee of a self-settled special needs trust, has full discretion to say yay or nay to a distribution. They have to, because if the beneficiary could demand it, it's available to them and countable. So you have to give those trustees a lot of discretion, and Alisha is going to be talking about some of the skill sets that are really important for selecting trustees. Third-party special needs trust can either be created during life, and that's called an inter vivos, just during life trust. It oftentimes is funded as part of an overall estate plan. So we might be doing a revocable trust to avoid court, where people put their assets in and they say, child A gets a piece of the pie, child B gets a piece of the pie, and child C, we're going to pour their inheritance into a trust we created, a third-party special needs trust, and it's going to manage those assets during life. And the probate avoidance trust disappears, and the special needs trust ticks along for the child with disabilities or the family member with disabilities. The individual with disabilities, their money cannot go into a third-party special needs trust. If it does, you've just knocked them off benefits, because that trust doesn't have a Medicaid payback. Third-party special needs trusts don't have to repay Medicaid at the end of the day. So if folks have time to plan in advance, that's the gold standard. You don't always have that time, so the self-settled special needs trusts are there to drop money in and help an individual who needs to get on and preserve that assistance. But if folks can plan in advance, we're looking at a third-party special needs trust to hold an inheritance or receive gifts of something like that. Let me see. I think I hit on the high notes. Okay. So there's one last one I wanted to talk about, and so it's for how to plan for a spouse with disabilities. So, the federal rules, I have no idea why they write in certain things, and it says that if you're going to create a special needs trust for a spouse, it has to be created as part of a last will and testament. It has to be a testamentary special needs trust, as the gentleman had mentioned. It has to be overseen by a court. You can't have a privately running trust for a spouse when the first spouse dies. It has to be under a last will and testament. Why created by will is sitting in the federal law, I have no idea, but it's there. And so I have folks coming in and we're doing some planning for a spouse. And I just want to mention that a special needs trust for a spouse is a third-party trust. One spouse is setting aside assets for another person with disabilities to preserve their benefits. There's no Medicaid payback, but I can't keep you out of court. It has to be administered under a last will and testament of the spouse who died for the surviving spouse who's on benefits. Yeah.
I'm just gonna-
Yeah.
Okay.
You're gonna run the show?
You can do it.
Oh, I can run the show.
You can do that one. All right. So unlike an ABLE account, which we're going to talk about, an ABLE account can only receive cash. So there are no restrictions on an S&T on the type or composition of assets either the self-settled S&T or a third-party S&T can own. An S&T can own residential property, it can own rental property, it can own vacant land, and it can also own a home for the beneficiary. However, paying the carrying costs if the S&T owns the home that the beneficiary lives in, paying carrying costs for that home is a delicate dance. And that's probably more than we're going to get into today, but I'll touch a little bit on that. S&Ts can own tangible personal property like electronics, vehicles, adaptive equipment, musical instruments, to cash investments, bonds, securities, and income streams like a structured settlement, which would flow into a self-settled special needs trust, or some court-ordered payments that could just flow into an S&T. So, trust fiduciaries. So, trustee selection for an S&T is critical. The skill set for a trustee ideally should capture someone who can and will exercise good faith, independent judgment, and discretion. Someone who will take time to be educated on benefits eligibility rules and carefully assess distribution decisions. Someone who is fiscally responsible and who may engage experts for tax, investment, or legal advice. Someone who is able to promptly respond to requests from a beneficiary or even a benefits agency. Another optional person that could be involved in the S&T is what we call a trust protector. This is someone who can offer oversight of the trustee, type of checks and balances. The trust protector can hire and fire a trustee under specific conditions. They can ask for accountings. Trust protector can advocate or offer input on the use of funds for the beneficiary as well. So a recipient of needs-based public benefits, again, that is government benefits with very strict income and or resource limits like SSI and Medicaid, must advise relevant agencies of both a beneficiary's or a S&T's receipt of any funds within specified timeframes. This is usually 10 days of either, again, that beneficiary or the S&T's receipt of funds. And also provide to the relevant agency, when an S&T is in play, a copy of the trust document, verifications of when it was funded and the type of asset or assets used to fund the trust, and perhaps also verifying title on different types of assets that are in the S&T, like showing title to real estate in the S&T or starting value of accounts in the S&T. The recipient may also need to answer questions received from the benefits agency as well. So what happens after a properly prepared S&T receives assets? Well, the assets in the S&T are not counted against the beneficiary. But how the trust assets are distributed by the trustee must be done carefully, especially if the beneficiary is on a program with income limits. Since SSI is intended to provide for a person's basic needs, S&T distributions for items that are considered food and shelter expenses will be counted as a type of income called in-kind support and maintenance. That's that ISM to the beneficiary. ISM counts as unearned income in the month received by the beneficiary and reduces the SSI check by approximately 1/3. So if a trustee pays the rent for that beneficiary in the month, and let's say we had talked about the SSI check, the maximum that a recipient can receive per month is about $943. If the trustee pays for that recipient's rent in that month, it's going to be reducing the SSI check by 1/3. Cash, on the other hand, cash in the recipient's hand reduces the SSI check dollar for dollar. So if the trustee pays rent, if the trustee gives the beneficiary cash in hand, $943 to that beneficiary in hand, the trustee is essentially knocked the beneficiary off of SSI because it reduces cash in hand, reduces SSI dollar for dollar. So Medicaid, on the other hand, if a Medicaid recipient gets cash in hand, the Medicaid recipient's program income limit, we're going to see in a minute, it might not knock that person off of Medicaid, but the trustee has to do this delicate dance of knowing what the income limit is in order to make a cash distribution to that beneficiary. So the bottom line is, don't give cash in hand to a beneficiary unless that beneficiary can handle it. It's underneath the income limit for whatever program that that beneficiary is on.
So I want to mention one thing.
Mhm.
So there was a lot of advocacy. For years, SSI was designed to pay for food and shelter. As of September of this year, distributions by a trust or a family member helping someone with food is not problematic. It's not in-kind support and maintenance as of September of this year. So it took a long time for the Social Security to realize that beneficiaries and individuals need to eat, and it shouldn't be, prohibitive. But that's sort of that's the delicate dance that we're looking at. Just wanted to mention that. Okay. Yeah.
Could you give an example of when you would give them a disbursement that, would make it ineligible?
To make them ineligible?
Right, or to end up in the dollar for dollar
Yes.
situation?
So I have a beneficiary, an advisor trustee. The beneficiary owns a home, and they're on a Choices for Independence Living, which has a pretty high income limit, and they're receiving Social Security disability insurance cash check of around $1,400 a month, and we have some wiggle room to get up to this $2,800 plus for the income limit for the Medicaid Choices for Independence. It's bringing her critical supports into the house. So we've got some wiggle room, and the trustee wants to pay the utilities and help that beneficiary out. And I've seen some special needs trusts that say you cannot make a distribution if it's going to count as income to the beneficiary. Our trusts say we're going to give a trustee the ability to make an informed choice. You can make that distribution. You can pay for the utilities. You can pay for the heat for that individual. Just watch the income limit. Don't push that income limit over the maximum.
Does that also come into play, now I forget the acronym, because acronyms, whatever, the benefit that was coming from the federal government for the internet, and then that got taken away, I think it was like $30 a month. So people could find themselves in a position with having an internet bill that they can't cover in that way.
So what's interesting, you want to field that one?
Yeah, so with the internet bill, the trustee can make a distribution to pay for the internet bill. That won't be considered a shelter cost.
But it's paid directly to the vendor.
Right.
So it's paid directly to Xfinity, directly to Comcast. They can pay for the phone bill. They can pay for the car insurance.
But
not those shelter expenses.
Right.
It's hard to figure out what's a shelter expense. You have to look at that program manual. Every single time a trustee comes to me, I'm like, I'm not going to say I know what it is, because after decades where food was a problem, now all of a sudden it's not, right? So we're pulling the manual out. Yeah.
Okay. So we're going to S&T distributions not treated as income. So payments to a third-party vendor for services or items that are not a shelter expense, and I'm going to give you a few examples of what a shelter expense is later on. But payments for the purchase of real estate to let the beneficiary live in won't be a distribution, will be an S&T distribution that's not treated as income, so long as it's made to that third party. Also, educational expenses, vacations, private caregivers, dentists, therapies, vehicle or car insurance, all paid directly to the vendor, not treated as income to the beneficiary. And any S&T distribution that supplements the basic necessities provided by the government program, those also are not going to be treated as income if you make a distribution to a third-party vendor. And what I didn't touch on this, but I'm going to say it now. If the Social Security Administration would disregard a trust distribution as accountable income for SSI determination, New Hampshire must do the same for Medicaid eligibility. So if food is coming off the roster, SSI is going to disregard any ISM for food. New Hampshire Medicaid has to do the same. It has to follow the SSA rules. All right. Not all countable distributions are problematic. However, a trustee must know the income limits for programs and which distributions are countable income to the beneficiary. For example, if the Medicaid income limit for a program is $2,800 a month and a beneficiary is able to work and get wages of $800 a month, or receives SSDI of about $1,500 a month, the beneficiary can still receive S&T distributions that count as income to the beneficiary up to that $2,800 limit. And sometimes a trustee may ask if they can pay a beneficiary's rent. The answer to this question depends on the type of program the beneficiary is on. That's why we're asking for award letters. We want to see what they're on. And whether the S&T owns the residence or if the recipient is renting from a third party. So that kind of tailors what our answer would be. Building flexibility into the S&T to navigate the future needs of a beneficiary and changes in the programs and rules is critical. So I just want to go back. So what can the trustee pay for and what is problematic? I know that's a topic that everybody's interested in. So the trustee can pay the beneficiary's phone or cable bill directly to a third party vendor. That's not going to be in-kind support and maintenance to the beneficiary. But if the trustee pays shelter expenses such as electric or heat bills, this is going to be ISM, in-kind support and maintenance to the beneficiary. And so some other examples of shelter expenses, in addition to the electric and heat I just mentioned, that would be ISM to a beneficiary, include property taxes, water, sewer, garbage bills, garbage removal bills, and that's just naming a few. There's a lot more shelter expenses, that's just naming a few. So while S&Ts are essential tools for planning for individuals with disabilities, before locking assets away for future use, it's important to set objectives and evaluate whether planning options for excess resources might be available or preferable to the person with disabilities. Remember, we're locking up the asset into a trust and they can't own, manage, or control it. So, for instance, can someone convert countable assets into non-countable resources in time to preserve benefits and spend down on something needed or wanted instead of giving up control over the assets? Or can the person with disabilities use an ABLE account to set aside some assets or future income without giving up that control and ownership? Or does the individual, if competent, want to give up control of the funds by locking them into an irrevocable trust for life? Or can the settlement, gift, or inheritance provide for that individual's long-term care needs without benefits? S&Ts can be used in conjunction with ABLE accounts, and the trustee of an S&T is often given authority to distribute assets out from an S&T to an ABLE account, presuming, of course, that the trust beneficiary will qualify for owning an ABLE account. And Judith is going to speak some more on ABLE accounts.
Okay. And then we'll come back for questions on both of the tools that we're talking about. So what is an ABLE account? Well, the authorizing federal law is the Achieving a Better Life Experience account. And so it's modeled after sort of a 529 education plan. The section of the federal law is 529A. It's a tax law. It's not a disability planning law, which is kind of unusual. ABLE accounts are investment accounts. They're investment accounts that can be owned by the individual with disabilities themselves. So they are running alongside a special needs trust, often when there's more resources than can be tucked away in time in an ABLE account. They're not trust accounts, so they're not outside of the individual's control. The ABLE account permits that person with disabilities to own one tax-advantaged ABLE account. And by tax advantage, I mean the assets in it are growing income tax-free, like a 529 education account is growing income tax-free, as long as it's used for a qualified disability expense. And just like an education account has to be used for educational expenses. So there are some qualifiers. So unlike funds in a regular bank account, the assets sitting in an ABLE account don't count toward the federal program's asset limits. So ABLE accounts let individuals with disabilities finally own assets of their own and not rely on a trustee to manage it for them. And if they, don't qualify to own an ABLE account, or individuals don't need all of their funds, locked up in a special needs trust, presuming they can handle the funds sitting in the ABLE account, or they have someone who can manage the funds, it's an essential tool. It may not be a substitute for a special needs trust, but it really is a game-changing companion tool for special needs trusts. I want to talk about the ABLE requirements. Okay. I took it and I just put it down. It's important to know that not everybody, as Alisha had said, there's some qualifications for participating in an ABLE account. There are some pros that I'm a big advocate for ABLE accounts, but there are also some drawbacks. And I just want to sort of give a high-level view of ABLE accounts and how they work and who can participate in them and some of the drawbacks to them. One of the limitations of the ABLE account is the age of onset of disability of the person who owns it. So like self-settled special needs trusts say you can't transfer assets into those self-settled safe harbor trusts, turn around the next day and stay on benefits. You have to be under the age of 65 in order to do that. Right now, ABLE accounts are only available to individuals who meet the definition of disability, but only if that disability arose before age 26. We have a pamphlet that we put together and we give it out at the Family Support Conference, and it's called the Milestone Ages. And I just wish the ages didn't, they're not like 18 and 22 and 26 and 65. But 26 is an important age, although that age, due to advocacy on a federal level, is going up to age 46 in January of 2026. So there's a lot of sixes there. So that's going to really open the pool for individuals who are able to participate in it. The reason for the age 26 was a fiscal note to get it past Congress, because they didn't want to open it up too wide. They kept it smaller, and they could anticipate how many people who were currently on those programs are now going to be able to put their money into an ABLE account. And they kept it at 26 because of a fiscal reason. But they're opening it up to under 46. An agent under a power of attorney, a parent, a guardian can create and manage an ABLE account for an individual with disabilities. And new rules were passed so that a representative payee also can do that management. It's not that new, but it was not part of the original legislation. There are a few limitations that are not related to age that apply, including only one ABLE account per individual is going to be excluded for those federal programs. So we've talked about SSI and we've talked about Medicaid and those resource limits, but there's also resource limits for the SNAP program, food program, for HUD and supported housing. There are letters that are issued by different agencies that are federally driven that require them to disregard the ABLE account as a countable resource or income coming out if it's for a qualified disability-related expense. The accounts can only hold cash, as Alisha mentioned, unlike a special needs trust that can really hold anything. And only the first $100,000 is going to be disregarded for SSI. If you go over that, the SSI will be suspended. But it's going to take a while to build up to the $800,000 for SSI, because the maximum amount that can go into an ABLE account annually from all sources is tied to the gift tax exclusion on the federal level, which is currently $18,000 a year. So it takes a while to build, and that presumes that you're not spending it on the individual before you get to that $100,000 cap and have to worry about it. The limit for what's in the ABLE account to stay on Medicaid is much higher. It's tied to the 529 limit for each state. And I think I didn't look it up before I walked in the door, so I'm sorry about that, but I know it's over $300,000.
I have the numbers on the charts. So.
Oh, thank goodness, thank you. So she looked it up, I didn't look it up. And so someone who's working, say they're on Medicaid for employed adults with disabilities, if someone is a wage earner and needs to stay on a Medicaid program, they're able to contribute higher than $18,000 a year if it's tied to their wages going in, but that also is going to have a cap on it. One disadvantage, and not a disadvantage, but something that folks should know, is that while all different people third parties can contribute to an ABLE account, the individual with disabilities contribute to the ABLE account, but ABLE accounts have a Medicaid payback at the end of the day. They're not like a third-party special needs trust. So if a grandparent wants to make all of these gifts, they may or may not want to drop 18 grand into an ABLE account, unless that money is going to be used over the course of the year for that individual. If they put it into a third-party special needs trust, it's there and it's available for use, but there's no Medicaid payback at the end of the day. The difference for the Medicaid payback for the ABLE account versus those self-settled special needs trusts, as I mentioned, for those D4A and D4C self-settled safe harbor trusts where someone has money and they need to put it away and stay on benefits, the Medicaid payback there goes back to the dawn of time. The ABLE account, the Medicaid payback is only from the date it was created forward for Medicaid assistance used, okay? So it's just, there's nuances. I guess sort of the key takeaway for ABLE is that it's another bucket into which assets can be put. And in comparison to the individual putting assets into a self-settled special needs trust, they own the assets in the ABLE account. They control the assets in the ABLE account. It's just not countable toward them for those federal programs up to the appropriate limits. Yeah?
This may be dumb, but when you talk about ABLE, you're talking about whether it's stable or ABLE, they're pretty much the same thing, right?
Yeah, and the stable was, New Hampshire participated in the Ohio Stable platform when they rolled it out, but they moved to a different consortium. So it's now a different program, but it's exactly right. They used to call it stable and now it's
New
ABLE.
Hampshire ABLE plan.
Yeah, New Hampshire ABLE
You should
plan.
be going with the ABLE,
Yeah,
is my recommendation.
okay. It's a better portal, perhaps. I've heard some feedback that they like the ABLE program
I
better.
went to somebody that got into some trouble and I tried to set up a quick stable account, which is now stable ABLE. And stable just was horrible. It took me 3 months of getting nowhere with them
Yeah.
after getting locked out of the portal. So I just sent in a paper application to ABLE.
So, just to be clear,
Yeah,
Stable
Stable.
is the company that's
That manages
managing
it.
the ABLE Act.
Yes.
Yeah.
It's not
the type of account.
Yeah,
Yeah.
it's not Stable versus
Right.
ABLE.
It's the management, it's the
Management company.
Yeah, yeah. And they rolled it out in New Hampshire under Stable, and they participated in the Ohio plan because Ohio was the first to kind of get it off the ground, and a lot of states wanted to ride their coattails. Now they've got some of the kinks out of it, and they're using a different management portal and a management company. But these are achieving a better life experience accounts, whether they're called Stable or ABLE or anywhere. Yeah. So wanted to talk a little bit about how ABLE accounts can be used. And assets coming out of an ABLE account, as I mentioned, an ABLE account, assets sitting in there up to the threshold limits are non-countable resources, even though the individual with disabilities or their guardian can manage it, or a parent can manage it for them. But funds coming out of that ABLE account generally are not going to count as income to the individual as long as it's used for a qualified disability-related expense. And that definition is incredibly broad. And so ABLE accounts were designed to be used for paying for food and shelter expenses because it's the individual's own assets. They're non-countable, but they're just using their own assets, so you can't count it as income to them. It could also be used for all of the other purposes that Alisha had mentioned, any adaptive equipment or therapies, anything to supplement the benefits, but also food and shelter. And now we're not so worried about food, but shelter expenses are critical. So I just wanted to mention that, you know, when you're looking at whether or not someone needs an ABLE account or a special needs trust, if they qualify for both, you're probably going to have both. And the reason is I'll give you an example of why an ABLE account can be a game changer for when we have someone who owns a home in their own name, say. If the individual with disabilities owns the home, and the trustee wants to pay the taxes on that home, that's going to be in-kind support and maintenance if it comes out of a special needs trust. So we build into our trust language that says a trustee can transfer money from a trust into that beneficiary's ABLE account, wash it clean, and let it be used to pay the taxes. And so the two are running alongside, and they're being, you know, it's completely legal. It's just a way to wash it clean using the structure that the federal government put in place so that it could be maximizing the opportunities of the individual and using both buckets. You can't backflow it. You can't move the money from ABLE into say a third-party special needs trust because it's the individual's own assets. Third-party special needs trusts don't have Medicaid paybacks, so we're not doing a backflow. We can put it, we just build in a lot of bells and whistles to make sure that we're maximizing the tools that are available to the individuals. But that's kind of our primer on special needs trusts, ABLE, and public benefits. But you had a question, and I want to come back to that before we skip ahead. And then I was thinking that maybe we could send you the trustee handbook. We have a handbook that's put out by the Special Needs Alliance, which my partner and I are members of. It's sort of a national organization, invitational only, people who are focusing on special needs and disability planning. And we give it to our clients when they have trustees, and we want to share what a trustee can and can't do, how they should be managing the assets, what they have to look out for in terms of potholes. So it might be helpful if you wanted it. We didn't bring it today. But you had asked a question about a self-settled special needs trust and whether or not someone could dissolve it and get rid of it. I guess I just want to make sure I understood the question.
So an individual that has opened.
Thank you very, very much.
You're welcome.
Does anybody else have any
Sure.
follow-up last minute? No?